be grounds, I'm sorry, if it can't, wow. If it can't be grounds for a frivolous appeal for the same reasons that he delayed and appealed this case on every opportunity available to avoid paying the arbitration award and cause him to incur greater fees, then how can it support an even greater sanction?
But the court could have concluded that it was frivolous, but it was going to exercise its discretion not to award sanctions, even though it was frivolous. The four corners of the opinion don't really make it clear what the basis was for not sanctioning.
Well, I guess that is correct, Your Honor. The four corners of the opinion would not say that specifically whether they found it frivolous or not. They just found it non-sanctionable when he moved for a frivolous appeal under Rule 45. So I think we can maybe infer from that that the Court of Appeals found that the grounds that he moved for under sanctions, that unreasonable delay and greater fees, were not grounds which are similar to here, grounds for sanctions there. So it wouldn't have been
if we start inferring things like that, then what's good for the goose is good for the gander. Couldn't we infer additional matters in the findings of fact and conclusions of law that the trial court did in the case before us? I mean, we really don't want to wade off into that, do we, and start inferring things that aren't within the document?
That is correct, Your Honor. I wouldn't want you to infer something that isn't there. The only point here is that he moved for sanctions on similar grounds that he put in his grievance complaint. And the point was that there he didn't raise and obviously thought, or I don't know if we can infer, that he presumed that he knew the terms of the contract at the time. And he didn't raise that Mr. Bennett didn't have the right to appeal at that time in his motion for sanctions as one of his grounds. And that brings me back to the point of the contract, which is the position here, which I think is what ultimately issues whether there was a rule violation either under 1.15D or 3.02. If he had the right to appeal, then there can't be a rule violation. And the Commission concedes that because that is the only action that they are taking, or they are saying is he somehow violated one of these rules.
But how could there be a right to appeal where the fee agreement says that the arbitrator's decision shall be binding, conclusive, and non-appealable, and that signing the agreement will result in the loss of the right to appeal?
Well, Your Honor, may I respond? I think what the Commission is saying, they want to put a period at the end of non-appealable, but you read the entire contract, you can't render any sort of the provisions under the contract interpretation, or it would be meaningless to just disregard the rest of the sentence.
Not appealable per the rules of the HBA arbitration.
To the rules and regulations of the Houston Bar Association Fee Dispute Committee. And if you go to the Houston Bar, those rules, Rule 8.02 says the panel's decision may be reviewed by a petition of a court having jurisdiction in accordance with the Texas Arbitration Act.
And in what way is an appeal to the First Court of Appeals a petition to a court having jurisdiction in accordance with the TAA?
Well, the TAA would be a court of appeals has that jurisdiction under Section 171.098 of the Civil Practice Remedies Code.
But it's not a petition that you file with the Court of Appeals. It's a notice of appeal.
Well, it's whether it's a petition or he's taking the appeal, he may appeal to a court that has jurisdiction under the Texas Arbitration Act.
But that's not what the rule says. It says the arbitrator's decision may be reviewed by a petition to a court having jurisdiction in accordance with the TAA. So what I'm trying to understand is how is an appeal to the First Court of Appeals a petition to a court having jurisdiction in accordance with the TAA?
Well, a petition would be a court, well, I mean, even though it's not called a petition, it's still a court that has jurisdiction that hears appeals under the TAA,
sure,
whether there's an order confirming or denying, and that's exactly what he did.
No question. But then how do we give meaning to the non-appealable language that's in the fee agreement?
I think you have to harmonize the entire contract.
I agree.
And say that it is not, I mean, it's non-appealable, but then if you go on where the Commission actually, on page 14, they state that the arbitration provision would result in the loss of appeal, but the contract doesn't say that. If you carry on to the more provisions of the contract, if we're reading the contract as a whole, it says that arbitration may result in the client's loss of significant rights, including a loss of appeal. It doesn't say that he didn't have the right to appeal here, the arbitration award, under Rule 8.02 or the TIA when the district court confirmed the arbitration award. So that our position is, if you take the contract as a whole under the circumstances in this case where Mr. Bennett had counsel, get separate counsel before, as he was consulted, and they had negotiations, so the contract shouldn't be construed against him, as the Positions Commission would be. You would harmonize the entire contract and all provisions, and if you harmonize all the provisions, you can't disregard the sentence or the words after non-appealable. I mean, it doesn't say it's ended the story, it's non-appealable. It's non-appealable pursuant to these rules. And if you carry on to that, I think that he would have had the right to appeal. And even if he didn't have the right to appeal, this record is clear with abuse of discretion on the, I've got two different clocks here. I'm sorry, was that?
You've gone 1 minute and 30 seconds over.
Okay, I'm sorry, Your Honor. I'm going to sit down and I'm going to save the rest for rebuttal.
All right, and the questioning took you a little bit past your time. You'll have your full rebuttal, and the commission will have an opportunity to speak as needed.
May it please the Court. I'll deal with that last issue first. Oops. Well, that's why I don't do this. Excuse me, Your Honor. The concept that you can take a contract with a client that you have a fiduciary duty to and tell him twice in the same fee agreement that this is binding, conclusive, and non-appealable, and then come somehow to the conclusion that it is exactly the opposite, that it is not binding, it is not conclusive, and it is appealable, is not a reasonable construction of any fee agreement.
Can I ask you to
Please.
take one step back?
Of course.
Because a concern that I have is this. Even if we were to conclude that the contract cannot be construed to allow an appeal to the Court of Appeals, the fact of the matter is that it is a not infrequent occurrence in this court for appeals to be pursued when they ought not to be pursued. They're interlocutory. They're not really appealable. All manner of things come up where we get into it and it's determined that we don't have jurisdiction or otherwise the appeal can't go forward. If that is a basis for disbarment, then there's a fair number of lawyers walking around town who are at risk of disbarment, and that is concerning.
Okay. Several different things we should talk about. One is they're not doing it to their own client. In any of those cases, you don't have the attorney as the adversary to their own client saying, client, even though you're saying I don't have a right to appeal, I say I do. Okay? So you have the fiduciary relationship between the parties, which is, I think, completely different from the situations you're talking about. Number two, you don't have in any of those situations, I would suggest, a contract that says it's not appealable. Okay? It's somebody's making an argument that despite the waiver, despite some legal barrier, etc., some non-contractual prohibition on appeal that they're appealing anyway. So I think the second factor is that you have a contract. First is you can't do it against a client. Second is you can't do it with a contract.
So if there's an arbitration clause, for example, and you shouldn't be in court, there's a dispute about whether you should be in court or should be in arbitration, and there's a dispute about the scope of the arbitration clause. If you guess wrong and it turns out you shouldn't be in court at all, you should be in arbitration, then the lawyer can be sanctioned for that?
Could be sanctioned for it. Now, whether that's disbarable
Really?
or not,
Okay, so if the lawyer guesses wrong and the clause says arising under, and they say, well, this didn't arise under the contract, it's not that close, then
With a client, the rules I submit to this court should be and are different. You don't you don't have an option as a lawyer to treat a client as a stranger. Your fiduciary duties, your fiduciary relationship has not ended, and you cannot do things under our rules, okay, that you could do otherwise. You could hold on to money that you have from, that the other side says, this is my money, give it back. You can hold on to that money if they're not your client, because they're strangers to you. You have no fiduciary relationship, you have no fiduciary duties, and you don't have a disciplinary rule that says if you hold on to unearned fees, you are violating this rule. It's completely different. The same thing with respect to 302. Okay? You can pursue hardball tactics like Mr. Bennett pursued here. You can pursue scorched earth if you want to as a litigation tactic, okay, when it's not your client. But when it is your client, the rules and fiduciary relationships preclude you from doing that. Now, if you do it anyway, it seems to me you are at great peril. You take a really significant chance that you are going to be found liable or guilty of a sanctionable event. Now, in the case of an unearned fee, what would I do? I would tender that money to the registry of the court as quickly as possible. In this case, that didn't happen. The money didn't get tendered to the person to whom it was due for 2 years. Okay?
Well, some of the fee, and that circles back to the question, we're talking about one of the bases under 1.15. Was it an unearned fee? Well, at the time of termination, it was disputed as to whether it was an unearned fee, and at the end of the procedures, turns out he was entitled to some of it, not all of it, but some of the fee, and that was a process that went on for some period of time. So is it really accurate to say that it was an unearned fee at the time of termination?
As long as we're talking about the 27.5 figure and not talking about any of the other figures, it is absolutely, positively, categorically an unearned fee after the arbitration panel makes its final decision, and certainly after it's confirmed by the district court.
And until that time, it's disputed.
It is disputed. No, go ahead. No question.
But that's what your finding says. Your finding says, upon termination of respondent's representation, respondent failed to return an advance payment of a fee that had not been earned.
Right.
So where is the evidence in the record that at the time of termination that fee had not been earned?
Well, that was the conclusion of the arbitration panel.
Well, I'm not sure that it says that it wasn't earned in the arbitration award or in the order.
Oh no, it most certainly
says
does.
in the order on the motion for clarification at page 9, they're assessing whether the fee was reasonable or not. But why is that the same question as whether the fee was earned or not?
If you go on to pages 13, 14, I think it finishes on page 15, you will see them do a micro-analysis of each category of the total amount of fees in dispute.
So that the panel could assess the reasonableness of the charges on a category-by-category basis.
That's right.
So what's the authority that tells us that reasonableness is the same thing as whether a fee was earned or not?
They go on,
Okay.
okay, on those other pages. They say, we have come to a firm conviction that this was an overcharge and that it was, the phrase was, took advantage of the client. They then say, they go on in the same pages that I'm talking about and say, any reasonable lawyer would have told their client these claims were not worthy of pursuit, they should not be spending money for them, and when it did, when that didn't happen, that was a serious problem in the eyes of that arbitration panel. So they didn't just say, you need to give the money back. They found that there had been an abuse. An ethical abuse is my phrase for it, when you say you took advantage of a client and any reasonable lawyer would have told them you should not be pursuing these claims and not pursuing these activities that I'm going to be charging you for. That is beyond the pale.
But even if you're right about that, that doesn't establish that the fee had not been earned upon termination. It only establishes that the fee had not been earned upon confirmation of the arbitration award.
You could make that, I mean, you could parse it that way, but I honestly believe you can say that it wasn't earned, okay? Just because it was billed doesn't mean it was earned, and he billed it, okay? So if you're saying unearned by adjudication, which I think is what you're saying, you're right. If it's unearned by law, by rule, then it's unearned at that time, even before there's an adjudication that it's not earned.
Let me shift gears for a second.
Sure.
What do you envision happening if we find the evidence insufficient as to one of the court's findings that was violated?
Okay.
Are you envisioning an entire new trial? Or are you envisioning a remand to reconsider sanctions? How do you think that would work?
If you only said, no, we disagree with one of the two, we think that the other one is sufficient for disbarment.
And what is your authority for that? Let's draw an analogy to a criminal trial.
I don't have
Let's
a case
draw an
on
analogy
point.
to a criminal trial. All right. So punishment is assessed either by the judge or the jury, and punishment is X. Appellate court finds that improper evidence was admitted during the punishment phase of the trial. Then it would be remanded for a new punishment hearing.
Yes.
So why wouldn't this be analogous to that?
I think it would be. I think it would be. I think that would be the proper result. Not going back for a complete retrial, but back on punishment, if I understood your
That was my
your
question.
hypothetical. Okay. So where to go now? The problem here is that you have not just, a terrible abuse of a client as found by an arbitration panel. You have a terrible abuse of the client subsequent to that, and that's why disbarment is appropriate. Okay? For me, the biggest thing to point out to this panel is to take you away from the appealability issue, which you're all over, but to take you to the conclusive part of the phrase. The phrase was the arbitration panel's decision will be binding, conclusive, and non-appealable. Okay? Appealability is a procedural thing, and people can argue about whether or not it's appealable under the TAA or the FTC. You can't do that same game with the word conclusive. If the arbitration panel's decision was conclusive regarding the fee dispute, okay, you can't pursue it because legally conclusive means game over. Okay? Binding supports that. Okay? You're stuck with it. Okay? Practically speaking, you're stuck with it, means for binding. But for conclusory, I submit to you that means legally it's been disposed of.
So I guess implicit in that, trying to think it through, is that you're saying if you agree to language like that in your fee agreement, then you're giving up all the admittedly limited bases of attacking an arbitration result, even if you have videotape of an arbitrator receiving a bribe, you're giving that up. I mean, in a imprecise sense, arbitration results are not appealable in the sense that an appeal is available from a final judgment, but there's still limited ways to try to challenge it. And it sounds like you're saying you give up everything.
We're not saying give up everything. Okay? We're saying give up everything past the confirmation in the district court. Okay? The fee agreement itself says, it contemplates that the award of the arbitration panel will have to be confirmed, may be confirmed by the district court. Your situation, Justice Boyce, fits into that. If you've got corruption of the arbitrators, you take that to the district court. They, in fact, filed a motion to vacate the arbitration award. They didn't have anything as good as, I paid off the arbitrators. But so there would be limited review in that part. But what I am saying.
And if the videotape comes to light after proceedings in the trial court, then I understand your position to be you've given up that right because this language is so clear.
Exactly right. That is exactly right. And I want to be even more emphatic about that. What this client and any client is told by the language of this fee agreement is, if there's a fee dispute, it's not going to be handled in litigation. It's going to be handled via arbitration. So my advantage as a lawyer, and obviously you're coming to me because I'm an 800-pound gorilla in the courts, is not going to be available to me in a fee dispute context. We're going to we're going to submit it to an arbitration panel or the Houston Bar Association, and I'm going to be precluded from taking this into the place where I've got all the power. And in a fiduciary relationship, that kind of representation is very important, and it was flagrantly abused.
Part of the concern here is a line drawing issue because you can find many examples, Anglo-Dutch among them, of vigorous, long-fought fee disputes between lawyers and their former clients. It's a larger part of the docket than one would imagine. It comes up fairly frequently. And this, you know, this is the nuclear option that was applied here. This is disbarment arising from a circumstance that tends to come up in the sense of a fee dispute between a lawyer and a former client fairly often.
Not with this contract language. That's what is the pivotal issue in this case. You don't have anything remotely like a promise by an attorney that the fee dispute is going to be contained in arbitration and will be binding, conclusive, and non-appealable. Okay? So in all those cases in your docket, I mean, certainly Anglo-Dutch didn't have that feature. And I'm not aware of any. We haven't come up with any cases where there was any language like this, and I'm sure if there was some, you'd be hearing about it from the other side. So that's what makes this such a distinguishable case. When a client is promised contractually, and it is not the client's. In Anglo-Dutch, it was the client's provision that was, had to be construed against the lawyer. Here, this is the lawyer's own provision. And it promises, I'm not going to hold on to a fee. When the arbitration award comes down, I am going to pay the disputed fee. And if there was unearned money, it should have been precluded by that. The same thing with the years of litigation. And it's not just the appeal, and I know I'm running into extra time. It's not just the full gamut of the appeals. It's two other things that are very distinguishable. Number one is the separate fraud lawsuit for punitive damages that was filed at the same time that appeal was taken to the First Court of Appeals. What is going on with that? If that's not vexatious, if that's not harassment, if that's not intimidation by a lawyer of his client, saying, I am suing you for something that is not dischargeable in bankruptcy, and fraud is this great, incredibly amorphous, virtually standardless thing of liability that tort form hasn't touched, okay? And I'm suing you for punitive damages. You are a non-lawyer and, frankly, someone who sees bogeymen, frankly, to start with. That is a blatant attempt to intimidate and harass a client. I will leave you with this thought, and that is, if you reverse this case, what signal do you send to the bar and what signal do you send to the public? Okay? Someone who was disbarred, and when Mr. Bennett asked that his disbarment be suspended, the trial judge who had heard all this evidence, read all the evidence, and his witnesses said, I am not going to suspend disbarment because of the public safety, public interest. She understood that this was, in her view, you'll decide for yourselves, this was something that not only merited disbarment, but the public had to be kept safe from this person. If you reverse, what signal does that send to the public? It doesn't make any difference. I mean, that's a very weighty consideration. And what signal does it send to the bar? If you can enter into an agreement that says it's binding, conclusive, and not appealable, and you can ignore it with impunity, and the courts will tell you it's okay, lawyer wins, client loses, that's an endorsement of a scorched earth policy toward clients that, frankly, I don't believe you can square with where the Supreme Court has been or will be. Thank you, Your Honor.
Thank you, Mr. Roach. Mr. Wright?
May it please the Court, I'd like to start where Mr. Roach ended. What kind of signal are you going to send? I think you ought to send a signal to this commission that they ought not misinterpret their own rules, try to apply them in a case where they don't apply, and intimidate a lawyer who, at worst, breached his contract. And to go in and now we have this, the trial judge heard it. This record drips with sarcasm, disparaging remarks, and other things that are unbecoming of a trial judge.
But there's not an issue on appeal regarding the trial judge's conduct. So could I ask you if you agree with Mr. Roach's point that if we reverse one of the two bases for a rule violation, do you agree that the proper remedy at that point would be to remand for a new sanctions hearing?
Well, I think that can be the only remedy. You know, the bar did not even ask for disbarment in this trial. Yes, it was in their pleading. They were not authorized to seek disbarment. And the sanction they sought has already been served by Mr. Bennett, who's been out of work for 18 months, since April of 2014. So I don't think they ought to be able to go back now and ask for more time. I think at worst, if this court affirms one of these grounds, you ought to say time served. But which ground are we going to...
But what authority... Go ahead.
I was going to say, what gives us the authority to do that, Mr. Wright?
Well, I don't know of any authority right now to do that, but for heaven's sakes, I think if you step back and look at what this man is accused of doing, even Mr. Roach said non-appealable is arguable, and he wants to go on conclusive. Well, at the hearing, the bar took the position that it was okay for Mr. Bennett to ask for rehearing in the arbitration. Well, arbitration ruling is conclusive. How can you ask for a rehearing? How can you go in and move for vacature in the district court like he did if it was conclusive? Their argument collapses on itself. They say it's okay to ask for reconsideration and to move for vacature because it's permitted in the bar rules. The bar rules also go to the TAA, and you're familiar with the argument about whether it's really appealable. There's a lot of language both in the contract, in the consent to arbitration that's attached to the contract, and in the rules that I believe gives us an arguable position. But even if it doesn't, are we really disbarring a man for making the wrong choice on whether he could appeal? You know, Mr. Land did not tell the First Court of Appeals that Mr. Bennett can't appeal under his contract. Mr. Land was represented by counsel in that appeal and did not even think to raise in the Court of Appeals, you ought to dismiss this because of his contract. It wasn't, and we have to assume they read the contract.
Let me ask you to address the Commission's contention that it's more than just pursuing the appeal. It's pursuing the appeal against a backdrop of aggressive counterclaims and satellite litigation that, to my eye, seem to fall within the broad findings and conclusions that the trial court made. In terms of 3.02, the trial court didn't limit it to pursuing the appeal when the appeal was not available. It's written more broadly than that.
Well, if you're talking about the lawsuit, that was non-suited, and there was no evidence presented about how that harmed anybody except maybe an answer had to be filed. But you know, the bar is not proceeding under 3.01, which has to do with not filing frivolous pleadings. And they are ignoring their own comments to 302, which say if a lawyer complies with 301 and 303 and 304, presumptively he's complied with 302.
But where are the findings that he complied with those other rules?
Well, they haven't even challenged.
Well, but that's just a non-finding. That's not a finding that he did comply.
Well, that's like saying, well, he might have committed fraud, too. They never pleaded it or proved it. I mean, you know, the other comment to 302, comment 6 says that it's not going to be a cause for disciplinary action when a lawyer takes legitimate actions in the interests of his clients. Now, Mr. Bennett's client, after he was discharged and when he's suing his client or his client is suing him, is himself. He doesn't have a fiduciary duty any longer. This idea that Mr. Roach puts forward that even after the relationship is over and you've been sued by your client, you have a fiduciary duty to your client? Really? You have a duty to put his interests ahead of yours? How are you going to file a denial in the case? That doesn't wash. And, you know, I think the court has latched onto the idea about this unearned fee. You can't have some determination 2 years down the road saying, well, that fee was unearned 2 years ago and you should have refunded it and, you know, you're going to get sanctioned. Even Mr. Roach said he would have put the money in the registry of the court. That's what Mr. Bennett did. He didn't delay 2 years. He put it in the registry of the court about 6 months after he filed the notice of appeal in the cash in lieu of supersedious bond.
Let me ask you to address the contention in the briefing that 3.02 is not applicable here because Mr. Bennett was not acting as an advocate. Why wasn't he acting as an advocate on his own behalf in this fee dispute to make 3.02's limitations applicable to this particular fight?
Well, you know, reading 3.02, I think it can apply to opposing counsel. But we've got to be very careful about that. And that's why comment 6 is so critical. So to directly answer your question, I'm not sure that 302 cannot apply to somebody who's representing themselves or representing an opposing party. But where are we going next? You made too many objections. You drug out this deposition too long. The bar is coming after you under 3.02, even though it was in the interest of your client to do that. And everything Mr. Bennett did and his firm and the lawyer that he hired to take the appeal was in the interest of the client, which was Mr. Bennett and his law firm. And again, you can't read that as saying, you know, once you've signed up a client, you know, you've got to, for the rest of your life, even after you're discharged and you've been sued and you've been accused of things, you can't defend yourself. This is, I recognize what you say, that the conduct of the district judge is not in question, but the idea that somehow we should defer to the district judge's observation of demeanor and so forth, I believe that that is called into question by the way that these proceedings were conducted. I mean, the district judge did not wish to hear evidence from experts that could have advised her about how these rules operate. And
complain about that in the briefing, but there was no objection when she left the bench. So was that preserved? And you didn't reoffer once the proffer was made. So was that really preserved?
I believe it was preserved. It was very clear. You know, the preservation rules just make sure the judge had an opportunity to rule on this. And she took every opportunity to say, I don't need to be taught about this, and I'm going to leave the bench, and you can make your bill of exception. I see my time has expired. I beg for 30 seconds to just close
Please
up.
conclude your thoughts.
We ask the court to reverse and render judgment that there's been no violation of either one of these rules because of the things that we've briefed and argued today. Perhaps as importantly, ask this court to expedite its decision in this case. My client has been disbarred, a sanction they weren't even authorized to ask for, a sanction far more. You know, last week I saw 3 lawyers who had been convicted of a crime, and the state bar suspended their license while the criminal conviction is on appeal. Every day you read of lawyers being disbarred for stealing money. This man didn't steal any money. He kept money he had a dispute with until the dispute was finally over and the client got the money. And that's it. And if delay and the bar's ability to come in and claim that somebody's unreasonably delayed or unreasonably taken an appeal is now the standard, we are all in trouble. You know, I don't do this kind of work. I usually stand up here in support of people who've lost a money judgment. It's just money. But I took this case because if I don't stand up for him, who's going to stand up for me when my turn comes? So we urge the court to reverse and render and to do so expeditiously. Thank you.
Any further questions? All right. This case is under submission, and we are adjourned.